Hello, my name is Paul McFarlane. I'm a partner in the employment team at Capsticks, and I'm going to hand you over to my colleague Nikki Green.
Hi, I'm a legal director in the employment division of Capsticks. Over the past 2 to 3 years, we've seen a significant increase in the number of queries we've received about positive action provisions of the Equality Act and how they can be used to improve workforce diversity. We've produced written guidance notes, which are on our website, and also webinars and seminars and workshops. And today, Paul and I are going to be discussing some of the questions that were asked at those seminars and workshops. Hopefully this is a useful resource for you and your team.
So, Nikki, can you just give us a quick overview of what positive action means in law in the UK?
Sure. So under the Equality Act, we have Section 158 and 159. Those are the positive action provisions that we have in the UK. Section 158 is about general positive action, and that will be things like targeted advertising, mentor schemes, buddy schemes at work that are aimed at people with a particular protected characteristic. Section 159 is about recruitment and promotion, specifically about recruitment and promotion. And there are particular criteria that have to apply to each of those sections in order for action to be positive action rather than positive discrimination. There's a very fine line between the two. So under Section 158, in order for an employer to be able to rely on the provisions, they have to be able to reasonably think that, and that's an important point actually, there isn't the need for sophisticated data on the part of the employer in order to rely on the positive action provisions. So they need to reasonably think that there is a disadvantage suffered by someone with a protected characteristic, that they have particular needs which are different to those who do not have the protected characteristic, or that participation in a particular activity is disproportionately low by people with that protected characteristic. So it can be one or more of those three. And then an employer also has to show that the steps taken are proportionate. So they have to have a legitimate aim that they're trying to achieve. Workforce diversity is likely to be a legitimate aim, but also that the steps they're taken are proportionate. So they haven't gone further than they needed to have gone in order to achieve that aim. Under Section 159, an employer has to show that an individual suffers a disadvantage in relation to recruitment and promotion, or that, again, the same criteria, that participation in an activity is disproportionately low. And then there are some separate criteria that apply to Section 159 that is really important to know about, and that's that individuals must be as qualified as each other before you apply Section 159. And also that an employer cannot have a policy of treating people with a protected characteristic more favourably than those that don't. And there's also the element of proportionality that applies again.
Okay, so could you offer focused training to a specific group only?
Under Section 158, that's a kind of general provision, general positive action provision. You can, and employers do, and that's quite a popular measure to take under positive action. There's an important point to note about when you offer that training and whether it tips into Section 159 and whether it's purely 158. If the training is offered independent of any recruitment or promotion process, it will fall squarely under Section 158. That means that you can offer tailored training. You can offer mentor schemes, have-a-go days, for example, in the fire service, where diversity of firefighters isn't where fire services would like it to be. They do offer specific training to women and BAME individuals because they recognise that they need to improve the diversity of firefighters. And that's perfectly fine under Section 158. Where we come across a bit of an issue is if specific training is offered after the application form has gone in, for example, or as part of the recruitment and promotion process. Because of that point I mentioned earlier about not having a policy of treating people more favourably, there is a risk that offering training as part of a recruitment process would tip into 159 and would therefore be unlawful discrimination as opposed to positive action.
And are there roles that only could be open to those with certain characteristics?
Advertised for certain characteristics. Generally, if you put out an advert for a role, that's going to be claimed to be positive discrimination. But there are certain exceptions under the Equality Act. And the first one that people are probably familiar with is the occupational requirement. So there are certain roles where you can say that you only want someone with a certain protected characteristic to apply. For example, welfare roles in the healthcare service, or people of a particular religion to apply. And that can be, that is an exception to the discrimination legislation that we have. The onus is on the employer to be able to show that the protected characteristic is necessary for the role. And if they're challenged by an individual on that, the burden of proof falls on them to be able to show that that's the case. The other way in which you could apply, make an advert for a I don't want to say role because not a role, but you could advertise for training and aim that at people with protected characteristic. Where you get into difficulties is where there's an advert for people with a protected characteristic to apply for a role, because again, that's falling into section 159, which is very different from 159 because you cannot have a policy of treating people with a protected characteristic more favourably. I think there's an appetite at the moment to really try and push boundaries with section 158 and 159. So we are seeing a lot more questions about this generally, and some employers may want to take the risk, but I don't think we can say that advertising and for a role and saying that a protected characteristic is necessary. I don't think we can say that will comply with section 159 necessarily.
What about, this is in the past, I know a number of employers have sort of focused their advertising for roles at particular communities, so they've gone out wider than the normal outlets that they'd use in the past. What about that? Would that fall within 158?
I think the advertising for a position, if you're not saying that you necessarily have to have someone with a protected characteristic in the role, but you're advertising for the role generally, that would be permitted under section 158. You're targeting the advertising at particular groups because you recognise that participation in that activity is disproportionately low, but you're not excluding people who don't have that protected characteristic, and that's a really important point to bear in mind, I think. So some of the questions that I get asked when I'm doing these seminars are around quotas and targets and what's the difference between the two of those, and I wondered if you could explain that in a bit more detail.
So, quotas are where you specifically say that you're going to have a set number of people from a set group who you're going to recruit. So, for example, if you were recruiting 100 people, and you said that you were going to have, definitely must have 25 people from women or 25 people from a BAME community, that would be a quota. We'll come to the lawfulness of this at the end of what I'm about to say. A target is more an aspiration. So in that example, we've got 100 people, and you're going to say that we'd like to have 25 from a BAME community or 25 of women. But that's more an aspiration. It's not set in stone. It's not something that you have to do, but it's something that you'd like to do, and you'd set yourself a time frame for doing that. Quotas in law are problematic because if it's saying you must have a set number of people now, unless and it can be shown that having that set number disadvantages a particular group from another protected characteristic, then you start to come into problems. So quotas have always been ones which employers have been wary of and need to think about quite carefully. I mean, my advice would be never to say that you're going to have a quota, but instead apply for a target and then work towards how you're going to achieve that target.
I think because we do see a lot of targets, don't we, at the moment? An awful lot of organisations are setting them. In the NHS, for example, NHS Improvement set a target for all NHS organisations to have a 50-50 split in the board by 2020. And I don't think that was quite met, but significant gains were made. And I think it helps to focus minds, doesn't it? Yeah. Whilst sticking to the right side of...
Yeah, and you're right. Targets are something that organisations are much more being encouraged to use more. The thing about a target, for it to be an effective target, is that there needs to be accountability at the top, at a senior level. Someone's got to be accountable to try and achieve that target. And in one instance, a law firm, they had targets in terms of the LGBTQ plus community that they wanted to achieve. And the way they went about achieving those targets was setting a target on their HR director who had to report directly into the managing partner every quarter about how they were going on their journey to achieve that target, and where there were deficiencies, what they were trying to do to address those deficiencies. So targets are something that are permitted within the law, but I say there needs to be accountability for it to be effective.
Okay, so another question that we're getting an awful lot at the moment is about the application of the Rooney Rule and whether organisations can rely on that to make sure that they have at least one BAME candidate in their pool for interview, and whether that is legal under the legislation in the UK.
Okay, let's just explain what the Rooney Rule is to those who are not familiar with it. So the Rooney Rule, firstly, has got nothing to do with Wayne Rooney. It's a rule that was devised in America from the National Football League, their American Football League. And it was came up by somebody called Dan Rooney, who was one of the general managers within one of their teams. There are 32 teams within the National Football League. And I think by 2003, they only had 3 BAME head coaches. And you've got to remember or think about that in the National Football League, 70% of the players are from a BAME background. So clearly there's some disparity there, and there was concern that head coaches were not reflective of the population of players, and why was that? So what Dan Rooney came up with was this idea that whenever a head coach position came up, there had to be at least one BAME ethnic minority person who was selected for the final selection stage. So they weren't put into the role, but they were put forward. At least one was put forward to be considered at the final selection stage, and that had quite a dramatic effect. So I think between 2003 and 2010, the numbers increased to around 8 BAME head coaches. And in their Super Bowl, which they have every year, which is their equivalent of the FA Cup, so there are 2 teams, over a period of 10 years, 10 of the head coaches in the Super Bowl were from a BAME background. Now I say, over the last few years, the figures have not been as great. So the one thing I would like to emphasise is that the Rooney Rule is not a panacea to resolving issues around the lack of representation of a particular group, but it is a tool that employers can use. Now, the second part of your question was the lawfulness point. That has raised issues around whether it's lawful or not. And it goes back to the things that we were talking about in terms of, can this sort of fall within positive action? Particularly, can it fall within Section 159 of the positive action provisions? And we do have some concerns about that, because what effectively it is doing is putting one particular, placing a policy where a disadvantaged group gets an advantage, namely one person is automatically, from that group, is automatically selected. So on a strict legal reading, it seems that that does breach the Section 159 provision. However, I think when you look at this, you've got to look at it in the round. And you've got to look at it in terms of, one, what other measures have you been taking prior to implementing the Rooney Rule to try and increase your representation amongst your disadvantaged group? So if you've been doing a lot of measures under Section 159, which Nick has explained, that will help. But also, what are the risks around a claim? And my personal view is that the risks in terms of the claim may be successful, but in terms of compensation, it's probably going to be relatively low, because what the disadvantaged person will be able to show is that they had a loss of a chance of an opportunity to get a job. They can't say that they would definitely have got that job. And so query whether or not somebody is going to bring a claim in those circumstances where the compensation, if they do get to that stage, is going to be relatively small. But I mean, that might be a controversial view, and I'm quite happy to have a discussion around that. But that's my personal view. So I think it's really it depends on the organisation's appetite for risk around that issue.
Yeah, because I think we haven't got any case law, have we, on the Rooney Rule, basically? No. And all we do have on Section 159, the recruitment and promotion process, is the furlong case. And that decision was really about who you actually recruited, whereas if the application of the Rooney Rule is about who you're selecting for the interview pool. It's a different stage of the process. But still, the risk must be there that Section 159 applies. But I agree, I think it's really about risk appetite amongst organisations and how far they're willing to push the provisions in order to try and improve workforce diversity.
Yeah, and I would agree with that. And more and more organisations are using it, or at least considering it. And it will depend on your organisation's appetite for risk. But as I say, the other point, which I think is really important, is if you have been trying to do other things to try and improve your representation, and they have either been ineffective or not as effective as you would like, then I think the Rooney Rule is an additional tool that you can think about using, notwithstanding the risks around it, but you can think about using in order to try and help achieve that. Because at the end of the day, what the Rooney Rule is saying is we're now going to put somebody before the final selection panel to see whether or not that panel think they are the best person out of, I don't know if they've shortlisted 5. So they're not when they get there, they're not automatically going to get the job, but they've got to demonstrate to that panel that they're better than the other 4. And so I think that presentationally to an employment tribunal, if you've been doing other stuff behind that, again, in terms of any compensation that would be awarded, I think the risks around that are low.
I think there's often some confusion around about the 2 ticks approach as well that applies to disability, and why can't that apply to other protected characteristics, and that we need to be clear that there are specific provisions of the Equality Act which apply to disability. But I guess if we're going to get towards an end goal of where maybe the 2 ticks approach could apply to other protected characteristics, that's really going to require a change in legislation. And we haven't seen that yet, but I think people are lobbying for change.
Yes, and I think that's right, because the 2 ticks, there is specific provision within the Equality Act that allows, in the context of disability, for that to occur. The government's set up a commission to look at racial inequality, and one of the subsets behind that is looking at it in the workplace, and query whether or not this is an issue that they will look at. We will have to wait and see what the outcome of it, because it seems to me that this is something that they could effectively use to try and give employers more tools, more armoury to enable them to better represent or have much more representative workforce. So we hope our overview of the positive action provisions has been of assistance, and as you can see, it is quite a technical area that employers need to get their heads around, but we hope that we've given you an overview of that and it will help you going forward.
If you've got any questions or any queries that you'd like to put to me and Paul, please do get in touch.